Well, have you noticed in this day and age of mail strikes, railway strikes, port strikes, as well as even airline disruption, there's a lot going on in the world of labor relations in this country. And so today we're going to talk about the state of labor relations in Canada in 2024.
A clear path forward requires looking back and learning. Good public policy requires human connection. It's a consideration of the facts, applying common sense and innovation. It's urban, it's rural, it's real life. We all have something to contribute. We all have a responsibility to get informed because there's a little piece of Canada in all of us, isn't there? Let's learn on this path together. This is Leaders on the Frontier.
Today we're going to talk about labor relations and who is serving whom. And you won't want to miss our discussion. And I'm very pleased to have our guest, and his name is John Mortimer. So a warm welcome to you, John, for joining us.
Great to be here, David.
Well, John, I'm really excited about our conversation because we're going to talk about the perennial elephant in the room, which is about labor relations. And I know you have a tremendous amount of background and experience and history as both an analyst as well as a columnist. And so I'd like to get your help in understanding some really basic questions around labor relations. And it starts off with the question, what do we mean by labor relations?
Well, we mean what happens when employees are unionized and what goes on between the union and the employer. Because the way it works is that employees give their rights to their employment to the union. And at the end of the day, the union has total, utter control and discretion. Yes, there are internal union mechanisms that employees can participate to some extent in terms of running for union office, voting on union resolutions at meetings, should they be attending them. And when it comes to strikes, one of the topics you raised earlier, it pretty much is always required in all the 11 jurisdictions across Canada that there be a strike vote. But to go to practical examples, unions will hold a strike vote and say, we gotta send the employer a message. We need everybody to vote in favor. So they get over 90%. But then they'll say to the employees in that meeting, but don't worry, before we take you out on strike, we'll come back and we'll hold another information meeting. We'll hold another strike vote. Well, this country's got history of unions where that was a lie to the unionized workers. The union didn't intend to hold a second strike vote, didn't hold another strike vote, and took them out on strike anyway.
Okay, wow. So labor relations then, if we're asking the question, why does this matter to Canadians? It affects us at every level of society, doesn't it, John?
Well, sometimes if it's a big actual strike or potential strike, such as a railway or an airline, there are lots of strikes that are a small business that might have 10 employees or might have 500 employees. And that is probably going to have a limited to almost no impact on almost all Canadians, but it'll affect those employees. It'll affect the suppliers of that business and the whoever owns that business and who they deal with.
So if you can help us understand, you're the president of the Canadian Association of Labourwatch. What is that organization?
So around the year 2000, we created a not-for-profit for employees that explains certain statutory and charter legal rights that they have. If we start at the charter level, the Supreme Court has said that an employee's got a right of non-association to not be a member of a union. Unfortunately, our Supreme Court has used the Section 1 proportionality or justification clause test, and they have said it's a justifiable violation of their 2D right of non-association. And so they've generally stripped that away from them when you come down and look at the actual legislated impact on them that compels them to be a member in order to keep their job or to get a job.
So in this country then, the right not to belong to a union, is that a free and clear right, or is it always not exactly the case?
Yeah, many of our labor codes allow collective agreements between unions and employers that say to an employee, thou shalt take thy pen from thy pocket and sign this union card and remain a good little union boy and girl. Otherwise, you're fired. Now, in some labor codes, there's some restrictions on unions and employers terminating a worker who loses their membership. But in some labor legislation across Canada, there is essentially no protection. And there are employees who have been terminated for losing their union membership or have had job offers revoked because the union said, we're not going to grant them membership as a new hire employee. So if we go back to this level, Labor Watch then went from that charter level down to the statutes, which says that an employee has a right essentially to join a union of their choice or not join a union of their choice. And we said, we're going to put the information online, the labor board forms, the labor board processes for every jurisdiction. How do I cancel my union card in a union drive because I've changed my mind? Hey, I'm unionized. I don't want to be unionized anymore. How do I remove the union, which is a legal right under every single labor code across the country? But it's not an even playing field. I'll give you a practical example. We have multiple jurisdictions that say that union leaders can collect cards and unionize workers without a secret ballot vote. Now, this would be legislation passed by politicians who are what? Elected by a secret ballot vote, not by people who run around a province or run around the country and go to your door and collect cards and turn them in and say, hey, we collected the most cards. We're the government. No, democracy doesn't work that way. But interestingly enough, there's only one jurisdiction in Canada where workers removing a union, and again, let's go back, they can get unionized without a secret ballot vote, just on cards, that are not properly vetted by a labor board. No matter what any union leader or labor board wants to say, there is not a proper process that assesses the veracity of those signatures, nor the manner in which those cards came to be signed. But when employees go to decertify the union, they always have to go to a vote, except in Quebec. So that's bias. That's unfair. Unions are multi-million-dollar organizations with professional union organizers, well-trained people who know how the law of organizing works. But our legislators, most of whom earn six figures and get elected by secret ballot votes in multiple provinces, have decided that workers can be unionized on cards, but those workers with no money, no lawyers, no resources, 99% of the time, have to not only collect the cards, but then they have to go through a vote where the union takes their union dues that they had to pay to keep their job and fights the decertification, campaigns against them, says you're going to lose your benefits, you're going to lose your safety boot allowance, right? They might use their lawyers to complain about the employee's decertification application at the labor board. And maybe they can force a hearing where a highly talented, well-trained union lawyer, paid billing several $100s an hour, goes up against employees who are probably there without a lawyer, having taken time off work and lost income to be in a labor board hearing. That's not fair. That's biased. That's not about workers. That's about the parties of labor relations in this country, which is employers, unions, labor boards, and ministries of labor. It is not true that labor law is about workers first and foremost. It is about workers last and least in many practical ways, as I've just set out.
Okay, so, gosh, that's quite an eye-opening summary then of the state of labor relations in Canada. I mean, you're watching the system, the process, the steps by which unionization occurs, and it sounds like, John, you're fundamentally calling out and saying this system is not fair. It's not transparent. It's not open. And frankly, the rules of the game are kind of tilted towards unionizing the workforces. Is that what you're really getting at?
Well, the Supreme Court has said in a number of its important labor relations decision that unionization is essentially a public good. My word, I don't know the specific court words, but that these imbalances are okay. But the problem is they're not about the least powerful party which is a worker, whether they're a minimum wage worker or they're a six-figure worker in the north or in a mine
Hmm.
or something like that. There's a broad range of pay, but there's an awful lot of people that are at or just above minimum wage, and they don't have the resources. They didn't go to law school.
Hmm.
And so, one of the most interesting things is that we're the last country in the world with independent unions and free collective bargaining that still allows unions and employers to sign collective agreements saying you have to become a member as a condition of employment. And number two, really important, we're the only country left that allows union dues in order to keep your job that can be used for politics, social causes, not only in Canada, but unions can send those union dues anywhere in the world for essentially anything they want.
Wow. Okay,
It's
so just
no,
back up for a sec. So you're
yeah,
saying that Canada is actually an outlier in the world internationally, where as a condition of employment in different cases, you have to be a member. And then on top of that, you have to give your money over to the union and they can use it for political activity, including social causes. Is that it?
send it to other countries, send it to a charity, give it to a political cause, use it for classic American style attack advertising has happened in multiple provinces across this country, usually against what people would consider a conservative or right of center
Wow.
political party. Okay.
So,
So,
and on top of that, the icing on the cake is that the courts have lined up to enable this. And on top of that, our elected officials are okay with this, generally speaking. Is that right?
well, because how many politicians are rubbing shoulders with minimum wage workers when we're talking about committees and lobbying? No, at the end of the day, it's employer lobbyists and union lobbyists at social functions. And I don't
Hmm.
care that there's a level of disclosure about lobbying. There is nobody spending hundreds of thousands of dollars or millions of dollars across this country over the many years influencing politicians on behalf of rank and file working Canadians.
Okay. But John, isn't surely that a good thing? I mean, if I were to play the other side, aren't unions for the working people? And so maybe if we have more unions, that's good for working people and better for Canadians then, isn't it?
Well, union density in the private sector is in decline because, as far as workers are concerned, and unions' own internal research and research that Labourwatch has done, unions
Hmm.
have a problematic brand. A lot of people think of a union as a four-letter word with five letters. Most union free Canadians do not like unions, do not want to be unionized in their own jobs. They
Hmm.
might, they'll say unions have a place in society, although most Canadians, or close to half, would say unions used to have a role, but they're not needed anymore. Okay.
Mm.
The dues are too high. I don't have a say in how they operate. They focus on seniority rather than merit,
Hmm.
performance, talent, qualifications, right? The number one complaint, according to Labor Board officials and Labor Board statistics that I've seen and that Labor Board chairs have, you know, shared with me, is a unionized Canadian complaining about their union.
Mm.
That's the number one administrative official application before labor boards. Labor board chairs have spoken to the board of directors of Labor Watch. They've talked about what a burden this is on their system. They've asked us to put content on our website to throw cold water on unionized Canadians, saying you really don't have much of a hope because most complaints against unions are dismissed on technicalities without a hearing. Maybe 1% of them actually succeed or reach an actual hearing. But the test for a union to fairly represent an employee is incredibly low. And I'm going to give you another practical example of the bias in our entire scheme. So, if you're an employer, your employees, with some differences across our 11 jurisdictions, can levy an employment standards complaint or a labor standards complaint against an employer. And again, setting aside the details, a government official can make contact with the employer. They can require production of documents and a conversation. And they, on behalf of the union-free Canadian, they can take on the employer. You can go to human rights, and certain human rights bodies will move a human rights complaint along with the employee through the system. And there's some similar mechanisms around workers' compensation and health and safety issues. It is consistent across Canada. There is no labor legislation statute in Canada where a unionized Canadian or a union-free Canadian can call the labor board, register a complaint, voice a concern, and that labor board official, that taxpayer official, is going to contact the union and say, we'd like to look at your records. We'd like to know more about this complaint against you. Now,
Okay, so
the
but hold on
employee,
for a sec. I thought unions were good for working people. What you're saying is the way unions are formed and allowed to run by the law, by the politicians, is not fair. Is that
well,
the bottom
it's
line?
not only not fair, but it doesn't challenge unions to be better because of what they can get away with. They can not take a grievance forward. That's their unfettered choice. They can settle a grievance at any point they want. And all they have to be able to prove against a typically unrepresented employee using their union dues to have the union lawyer or union staffer contest them is prove that their conduct wasn't discriminatory or wasn't arbitrary. Okay. And that test for a union is incredibly low. So I think that how do you take union dues from workers as a condition of employment? Give it to the union. How do you take taxes from them and fund the labor board and the Ministry of Labor and only provide help against employers on behalf of union-free workers and provide essentially no assistance? You know, the typical call of an employee to a labor board results in get a lawyer. We can't help you. I've tested that. I've posed as an employee and called multiple labor boards across the country to speak to something. I have never received any help. I've received misinformation, and then I've gone and shared those stories with the labor board chair, just demonstrating that you're not even-handed even in how you answer their questions.
Wow. So I think this would be a shock to a lot of Canadians that unions in Canada have such a privileged position. So how does this system, if it's not serving the workers, who is it serving then, John?
Labor board chairs would say, John, stop it. Please just recognize labor relations is about the institutional parties. A couple of labor board chairs have said to me in different words over the 2.5 decades that we've run Labourwatch to be of what service we can to Canadian workers. They've said labor relations about the institutional parties, meaning the employer, the union, the officials at the labor board, and the people at the Ministry of Labor who sometimes are involved in mediation and arbitration of bargaining or strikes or lockouts. Because, you know, and I mean no disrespect to the lawyers of employers and unions and the labor board adjudicators, the vice chairs, the judges that some people would call them that make decisions, who are very often lawyers. They're there making the system work the way it's been unfolded, designed, and upheld by our courts. And so they're working together to solve problems and solve the issues that come before them. But while there's occasionally employees who are witnesses in a proceeding, they're either there on behalf of one party or another to make a case out, or they're there alone. I have sat in labor board hearings at the back of the room while employees who are trying to get their decertification through have actually been disrespected in front of the vice chair, by the vice chair. And then I've seen in the same hearing, it was a shocking moment, the employer's very seasoned 35, 37-year management side lawyer was there with a young lawyer newly called to the bar and learning the ropes. And he was having this lawyer argue some of the case and ask some of the questions. And they were making mistakes They were making mistakes I could see. And that vice chair treated them with, like, actually helped them, treated them with respect. But then when the employee spoke, who came and dressed up in a sport coat and a tie, who knows? Maybe this person even went out and bought it because they felt like I should try to look as a professional. And they were actually an immigrant to Canada. And they were treated with disrespect. They were interrupted. They were cut off. They were told what they were wrong on. So in the same room, at the same labor board, within an hour, I saw exceptions made for this young lawyer. Lovely that they were helped out, but it was biased against the worker. It was
Interesting. So,
unfortunate.
so this system really begs a lot of serious questions. It sounds like you're saying the system, the way it's set up and is unfolded, it kind of serves itself.
No, it serves union leaders first and foremost. It serves employers second. And then, the labor board and the Ministry of Labor do their thing. But
Okay.
if we go to Europe, where I think there's now 46 countries that make up the Council of Europe, that's where we have the European Convention on Human Rights. And while multiple countries in the Council of Europe have had statutory schemes that allowed unions and employers to have collective agreements that said to European workers in that given country, you first have to be a member of the union to get a job, or the collective agreement was changed from membership in the union was voluntary to membership in the union is now compulsory, or even the country changed the legislation and said you have to be a member. And that's been struck down by the Court of Human Rights under their equivalent freedom of association. The European Court of Human Rights, I believe, has consistently stood in favor of the individual European worker without the money, without the law background, to be protected from forced union membership and forced union dues for non-bargaining purposes. And so,
So are you saying that compared to Europe, then Canada is truly an outlier because we don't protect the rights of individuals to have freedom to choose whether or not they even want to be part of a union and give their money to some political cause? In Europe, they're ahead of us, where we're behind. Is that what you're saying, John?
well, multiple countries used to be like us, but the court has taken that away. And you only need a ruling in one country to apply to all of the countries the way the European Convention works under the Council of Europe structure, which is different than the European Union, which has a smaller number of nations in it. If we go to United States, the Supreme Court down there at the end of the day has put an end to forced union membership as a collective agreement being enforceable. If we go to Australia, I don't think they've ever had legislation. Even the Labour Party of Australia, when Julia Gillard was Prime Minister of Australia, leader of the Labour Party, there's a letter to the editor she wrote that I've found and kept, where she talked about how in amending the labor statute federally, nationally in Australia, they had still protected that membership choice and not made a move to compel it because it's inconsistent with the ethos of Australian unions and the way it works.
Wow.
And then New Zealand, it's a more detailed structure, but it is the truest right to work country. It is the truly freest in terms of the choices that it gives a New Zealand worker. Now, I haven't checked in a few years whether a government has changed anything at the margins, but and if we go to countries like China, I don't know the current state today, but historically speaking, I've been advised by Asian labor relations experts that Walmart employees there are unionized, but they're in a union that's a creature of the Communist Party. Well, we don't have free unions in Communist China, and we don't have free collective bargaining in Communist China like we do have in democratic nations around the world. So, to call Canada an outlier, I'm calling us an outlier against democracies, not against countries
of course.
that are still
Yeah.
essentially communist.
Okay, so we've talked a little bit about the courts, the law really enabling unionization and really, frankly, undermining in Canada the rights of working people. Let's talk a little bit about politicians, elected officials. Surely they're in charge. Surely they care about workers. What is their role in labor relations in this country?
Well, left of center political parties, particularly the NDP, the Parti Québécois, the Bloc Québécois, have historically been very favorable to union leaders. Um, the NDP federally, haven't checked the current structure, but you know, unions, the Canadian Labour Congress, like they had automatic seats at the table at conventions and in decision making in not small numbers that didn't go through a traditional process, riding by riding, to select the people that are members of the party that are going to go there. They were members, so they had control and power, and they gave them money um, over the decades across the country. Liberals have been back and forth. Um, Under the prime ministership of this country of Jean Chrétien, I'm going to give a very practical example that connects to really important recent events today. The NDP and the Bloc Québécois, over the years, have put forward typically private members' bills that wanted to take federal labor law in the direction of Quebec labor law when it comes to strikes and lockouts. And the essence of it is this: up until this year, Quebec was the only jurisdiction in the world known to me that said during a strike, a unionized worker cannot cross their own union's picket line and go to work in defiance of the union. Why should that be the case? Well, first of all, I believe it's Article 23 of the United Nations Declaration of Human Rights talks about a right to work, a right to employment. And if you study the debates of the late 1940s that lead to the UN Declaration, you will see that the debates were that this was truly about freedom from forced union membership. So it's freedom to be able to go to work. So I'm going to give a practical example. I think around 2004, 2005, the telecommunications workers union that had TELUS, I think like 19,000 people unionized in the TWU, they held a strike vote, typical MO, give us a mandate, send us to the table, so they get a strong mandate for a strike. But multiple TELUS workers said that the union absolutely said that there will be another strike vote. I think bargaining ran somewhere around 5 months between TELUS and the union. There were multiple offers that the employer made. The evidence at the time was that the union, not once did it take a TELUS offer to those 19,000 people that had to pay the union to represent them and have control over them as a condition of their employment. So then they called a strike. Okay, some really important differences. In Quebec and Ontario, where TELUS had bought ClearNet, I think it was called at the time, about 1,100 unionized people got swept into the union without cards and without a vote. And during the strike, my information was not one person went on strike for 1 minute. They went to work every day and did their jobs. Some of them maybe didn't even know that they'd been swept into the union by the Canada Industrial Relations Board, because there was no proceeding that those employees were involved in. There was nothing really that they could do. In British Columbia, TELUS didn't trust the courts to enforce the rule of law. So they closed the workplace and said to unionized TELUS workers in British Columbia, you cannot come to work. And so they ran British Columbia with managers from across the country. In Alberta, they felt there was a really different culture amongst the courts, the judges, and so they opened the workplace. Approximately 57%, over 3,000 unionized TELUS workers in Alberta defied the union, went to work, and performed their jobs. Here's why this is really significant. So under Jean Chrétien, the Liberal Party of Canada, sitting in government, voted down every attempt by the NDP and the Bloc Québécois private members' bills to strip federally regulated workers like those TELUS people of their right to have some power against their powerful union, to create risk around strikes where you don't keep your commitment for the second strike vote, where you don't share the employer's offers with people, because our legal system allows you as a union to get away with that power move and that disrespect for the people that have to pay you or be fired from their job. Okay. So, what just happened in this country? Every single political party voted in favor of Trudeau legislation. So, for the first time, to my knowledge, and I'm prepared to stand corrected by my critics, the Liberal Party of Canada brought forward legislation to mirror Quebec and strip people of their workers, and they were aided by a full-on whipped vote.
Okay,
So
so
we've
to be
got
clear,
a
all
government
three major parties then
and a
are
bloc
really
and a
stripping,
bloc.
including the Bloc Québécois, are enabling and undermining the rights of working Canadians then with this labor legislation.
Absolutely. And I said earlier, I know of no other jurisdiction other than Quebec. Now, as a whole country for federally regulated workers, about 10% of the workforce come under federal labor law rather than provincial labor law. They're alone in the world of no longer being able to create risk for their union bosses, to defy their unions and come to work if the employer decides to open the workplace.
Wow.
But the employer
So,
doesn't have to
so,
open the
so,
workplace. That's
so
their
why are
choice.
these elected officials going ahead and enabling these labor bosses to rule the roost?
Well, I think the long arc for Conservatives goes back to something in Ontario that operated over multiple provincial elections called the Working Families Coalition, which cobbled together millions of dollars of forced union dues without consultation with those hundreds of thousands of unionized Ontarians. And they ran classic American style attack advertising
Mm.
against Ernie Eves, um, Tim Hudak,
Hmm.
uh, and others. Uh, and that was allowed under our legal scheme. Now, if I can just stop here for a moment, and I want to go back to one other important thing of law before I come to what's happened provincially in Ontario and now federally on the Conservative side, is our Supreme Court has said that forced union membership as a condition of employment is a charter violation, but as I said earlier, they've justified it. That's the advance cutting and coring decision of the Supreme Court of around the year 2000, 2001. The 1991 Levine decision of the Supreme Court of Canada, while it's a very complex decision, it's got 3 or 4 separate
Hmm.
decisions and it runs about 170 plus pages. I believe it clearly stands for the proposition that they find a charter violation for forced union dues used for non-bargaining purposes in Ontario.
Hmm.
But then they justified saying if the Ontario government overseeing collective bargaining of community colleges wants to allow a collective agreement with a union dues clause that says you must pay dues as a condition of employment, if it wants to have a statutory scheme that
Hmm.
allows that kind of section in a collective agreement, well, that's a justifiable charter violation. And there's this rationale given by the labor board for why they are going to strip Ontario workers of their charter right using the proportionality test, section 1 of the charter. And I
Hmm.
believe almost every human rights instrument convention in the world, in democratic nations, has a proportionality test on the
Right.
principle that there's no absolute human
The
right. Okay.
bottom line is that the law has enabled unionization to happen in this country. They've been able to basically undermine the freedom of workers to say, no, I don't want to be in that union, despite the fact that people in principle would say you have a right to work. And they've enabled a particular situation where they've been able to allow you to take your union dues and put it in huge pots of money for political advertising. And so the politicians are just behaving in a rational way, regardless of their party, to play along with what those union bosses want. Is that what you're getting at, John?
Well, let's talk about the Working Families Coalition, the attack on the Conservative Party, multiple elections over the decades. Premier Ford chose a different path, would be my observation. Factually, he became, in particular, very friendly with the Labourers Union, who did lots to help MPPs get elected in that first election. There's been a lot done by this provincial government and this premier for the laborers and against the carpenters. So the carpenters unions and its unionized Ontarian workers are getting beaten up, and they're going to get beaten up again in this next round of bargaining, and probably other moves that they'll make either before the next Ontario election or afterwards, where the carpenters will lose more jurisdiction in this province, and it'll be won by the laborers. And there's going to be big, powerful employers involved in that, employer associations involved in that, and that's just the way it's going to unfold, because he's got a majority of government now, and they're looking to have another majority government again. So what's happened federally, it seems to me, that the federal Conservatives have also decided, let's not have unions attacking us. Let's win the largest majority we can. So let's not have all sorts of money spent in third-party advertising and all sorts of attacks and work underneath and behind the scenes to go against us. Now, some Conservative politicians believe that by working with union leaders, they're actually reaching out and appealing to unionized workers. I say they're wrong. Andre Turcotte, when he did the research for the Reform Party, we're going to have to do a little history here, but according to him, according to the Reform Party leader Preston Manning, the Reform Party got more votes from unionized Canadians in federal elections in 93 and 97 than the NDP did. And so, unions get very low readership on their social media by the people they represent. They get very low participation in their meetings. And the idea that they're of influence in how unionized Canadians vote is not borne out by the research, not borne out my experience listening to people, thousands of people over the last 24 years of serving as the president of the Canadian Labourwatch Association, and just all my anecdotal experiences in addition to research like that of expert pollsters. So,
okay, so are you saying, John, that politicians then bow down to union bosses and legislation that enables unions because, well, they think that if they work with them, that somehow their members will come along and vote for them? Is that it?
Yes, but I think at the end of the day, unions will correctly say that unionized Canadians earn, on average, slightly more than union-free Canadians. That number's getting narrower, but it's statistically true. So to the extent that unionized Canadians earn above average incomes, they care about taxes. Unionized Canadians, some of them tend to be small d Democrats, and internal union procedures are not considered terribly democratic by lots of unionized Canadians. And I've seen lots of very specific circumstances to bear that out, as much as they're going to claim that they're democracies, let alone the fact that they lobby against secret ballot votes on getting in, but then they do nothing to make sure that they can have union cards used to get rid of them, back to the bias, like they don't lobby in favor of that. So it seems to me the federal Conservatives, by disempowering working Canadians in the federal sector, have done something that's unique in the world. If they think that stripping workers of their right to cross a picket line like 3,100 unionized TELUS workers did, I say they misunderstand working Canadians, and they misunderstand how they think about their unions. Unions in the private sector have gone like 30 to 15%. In Alberta, it's 9% union density. Okay. The reason unions lose a lot of union drives, can't get workers unionized, is people don't want them. So I don't understand union leaders having an appeal rather than Conservative politicians figuring out how to do what has been done in Australia and New Zealand and what's taken place in Europe to give them freedom from forced union membership, consistent with what the Charter says and every other country in the world. Freedom from forced union dues to be used for politics. I do not understand why Conservatives, who are probably almost never going to get donations from unions over the long run and are almost never going over the long run to not face attacks by unions against them as politicians, do not bring this country, province by province, into line with the rest of the civilized world and become free of forced union dues as a condition of employment for politics, social causes, and other parts of the world.
Okay, so obviously all major parties now in this country are guilty of this kind of unfair treatment of working people, and I like your vision of freedom within labor relations. So, is there a nation that you think would be a good role model for us in this country in terms of labor relations?
Well, I mean, any province can simply pass statutory legislation that, in its preamble, in its whereas statements, acknowledge that the Supreme Court has said forced union dues for political non bargaining purposes are a violation of the Charter. And so we're going to bring our statutory scheme in line with the Charter that
Okay.
says that's what freedom of association means. Second, they can bar collective agreements from compelling membership as a condition of employment and become consistent with the rest of the world and consistent with the Supreme Court jurisprudence. I love the Swedish history on this. When a Swedish government many years ago decided it was going to bring freedom from forced union membership in their country from collective agreements negotiated by powerful employers and powerful unions that stripped workers of their choice to be a member or not, they mandated in statutory law that on the next round of bargaining, every union and every employer had to remove that coercive anti-freedom language and make it free choice of being a member or not, but still being able to keep your job throughout the country. So
Okay.
that would be an
So,
example.
so Sweden is a great example of what we should be doing. Is that correct, John?
Yeah, and the other one would be New Zealand as I last knew it, which is if I join a company, the first choice I have is do I become a member of the union or not, if there's one in my
Hmm.
workplace. So I join the union and become a member, and then I pay full union dues that can be used for political purposes, non-bargaining purposes. Okay, I don't want to become a member of the union and pay full dues because I don't want them spending my money on politics. But you know what? I want the union to represent me in collective bargaining. And I want the union to represent me if I have a grievance with my employer. So you pay lower rate of union dues in New Zealand,
Hmm.
and you purchase the union's talent, expertise, and representation in a dispute with the employer. But what's most interesting is that if I don't want to become a member and I don't want to pay any union dues at all, I'm not covered by the collective agreement. And I have an individual employment agreement, as it was last referred to when I talked to New Zealand lawyers and studied the legislation. So you work alongside union members, you work alongside union dues payers who are not members as a non union, non member, not covered by the collective agreement with an individual employment agreement, and you're all on the same assembly line, you're all in the same retail store, and it works. And I don't know how many years it's been like that. I'd have to go check to see if it's still like that.
Hmm.
But that's real freedom because you're also free from the collective agreement, not just free from union membership
Hmm.
and not free and just free from union politics.
It
That's a
makes sense.
true workplace choice that I believe is the most consistent scheme with the United Nations Declaration of Human Rights and the debates that created that section of that instrument.
Okay, so let's have freedom in the workplace. So, John, just to pick up on the role of unions in Canada in the political process, can you help explain to me that is it public unions that play the biggest role within the political scene, and how specifically do they do it?
Well, I think that broadly speaking, a lot of unions, but not all of them, they're anti capitalism, they are anti entrepreneurialism, and so they want unions to have more and more power. They want legislative schemes that bring people within unions. And, we're 76%, last time I looked, unionized all three levels of government workers, but 16, 15% in the private sector across the country with provincial
Hmm.
differences. Okay. But there's still more unionized private sector workers. So because Trudeau ripped out the financial disclosure provisions of the Income Tax Act of Canada that were passed by a private member's bill many years ago, we don't actually know what union revenue is, but some people think it's in the order of
Sorry,
4 to 5.
wait a sec. You're saying that we don't know what the books are for unions anymore?
Not to the public. Some labor codes have provisions that enable a union member to get very limited financial information. But when I look at what unions are required to send by looking at actual employees who on their own, or they found pro bono legal counsel, tried to get their union's financial statements, they got a one-page income statement and they got a one-page balance sheet with no details and no backup on any line item whatsoever. When they contested that, the Labor Board of British Columbia, in this case, interpreted the words of the legislature to say, we can't get you anymore. Number two, when they became concerned about their union's financial conduct, this would be the United Food and Commercial Workers, and these were meat cutters in a grocery store who contested this, they tried to get more than the current year, and the union said no. So their lawyer that helped them fight this thing went to the Labor Board, and they were like, nope, you only get 1 year. If you wanted the year before, you needed to ask last year, and if you wanted 2 years ago, you needed to ask 2 years ago. So you don't get any history through our six-figure lawyer, Labor Board judge interpretation of the legislature. So they got 1 year's financial statements. And the union tried to force them to sign a non-disclosure statement that they wouldn't share those 2 pages with anybody else other than the 7 or 8 of them that went forward to try to get this. So they actually had to litigate against the gag clause into the courts of British Columbia. It took years for them to get nothing at the end of the day.
So if you're a union member, what is your hope of creating freedom of choice in terms of the use of your dues? Or like I notice that an awful lot of public unions are at the forefront of advocating for really, in many respects, are radical cultural socialist policies. Like we talk about like SOGI curriculum that advocates for children to be taught about transitioning at a young age in a classroom without the knowledge of their parents. There's a lot of radical ideology that is being advocated by a number of public unions. I mean, this is well known. So if you're a member of that union, how do you speak up about these issues and say, no, you're not representing me?
Well, we're still living through cancel culture in a major way. If you're worried that the union's going to put you on an internal union trial for speaking out, that you're going to be persecuted, that you could lose your membership in the union or be suspended under some labor codes, but again, not all of them, to the technical experts out there, you could lose your job.
So you don't really
And,
have
and,
a
and
voice.
they could let you keep your job, but they take away your ability to participate in a ratification vote of a collective agreement or in an information meeting about bargaining. They can just exclude you from everything once they take you out of membership if they want to. And the thing is that, what's happened in Europe, according to experts there, is because they have to convince people to be members, they have to convince people to pay full dues. So they've become far more focused on the workplace, bargaining, issues in the workplace, grievances, and less focused on politics than they were in the past when they could compel membership and they could compel union dues that they could use for anything as a condition of employment. So it made them more accountable to the unionized workers about work, and they weren't engaged in politics. They weren't engaged
Okay.
in going on in other countries. So it's changed the union movement in other parts of the world, but not in this country.
Okay, so this helps explain a lot of the political scene, the policy scene that's happening in this country, John, because you're basically confirming that unions have a incredible advantage, a privileged position to both unionize, control your money, and basically flood the political scene with their money using and advocating for a radical political ideology. That's really transformed
Well,
our country. That would explain a lot of it, wouldn't it, John?
absolutely explains a lot of things. And there couldn't be better examples than certain unions, such as OPSU, the union in Ontario that represents Ontario government workers for the most part. OPSU has some other unionized workplaces, I think some even in the private sector. CUPE would be another one that's largely public sector workers, but I've seen CUPE in the private sector in some parts of the country as well. And, you know, um, they were very much involved, some would say at the forefront of what I think are clearly, in some instances, anti Semitic, pro Hamas. That wasn't an encampment at my alma mater, University of Toronto. That was an occupation allowed by an incompetent leadership of the University of Toronto that went
Indeed.
on too long.
Yes.
And those unions used forced union dues, and they supported the litigation against the University of Toronto when U of T finally did something, okay? But they funded that litigation in the information that I've seen and what they've spoken favorably of, let alone the signs they produced, the flags they bought, and they attacked Israel. Some of these rallies, whether the leader of CUPE in Ontario, Fred Hahn, even the National called for his resignation. I don't think he's done it. The leader of OPSU, I believe the last name is Hornick, also was very much at the forefront. And, when you're chanting from the river to the sea, right, you mean genocide with forced union dues as a condition of employment. I'd like the Premier of Ontario and the future Prime Minister of Canada to pass very, very simple legislation that aligns the Ontario Labour Relations Act and all of the federal labor codes with the rest of the country, with the Charter of Rights, and with the decisions called Advance and Levine, where we will have statutory schemes that bring freedom to choose membership or not to working Canadians, and bring freedom to have your union dues used for politics and social causes or not. And if we're going to be freedom oriented with our next government of Canada, when the current regime is taken out, I really hope that freedom means something for the working Canadians, that the leader of the Conservative Party, the leader of His Majesty's loyal opposition, he wants to appeal to working Canadians, then start to create legislation that will create better unions and better union leaders that are focused on work and not on politics.
Okay, so that's a major challenge that you've issued to all parties, including the Conservative Party policy. And I think what's interesting about your challenge, John, is that this is not only an issue relative to public policy, but it impacts the culture of this nation as people, really frankly, whether they have a voice or not, as working people. It's really quite a fascinating issue. It's almost like this is like the elephant in the room when it comes to defining politics in this country today.
They have too much power over unionized workers. And too much power is never a good thing for accountability and for raising your standards. We have what amount to compelled customers. I don't think we want to have a country where you're compelled to shop at one grocery store. You're compelled to get your cell phone from only one place. And yes, you can change unions. Yes, you can remove your unions, but it's difficult. And when the union can get in on cards using talented professionals and lots of money, and you're a unionized worker and you want to remove the union, and it's a complicated legal process. And yes, it happens. And yes, some workers achieve. But unions take your union dues and fight against workers. And you can't call the labor board to contest union misconduct like you can contest employer misconduct, as I said earlier. So this causes union talent at its senior levels to go down because they have too much power. they can get away with too much, and they're not really accountable. And our labor boards, I've just seen it too many times, okay? I've read the stories. I've sat in these labor board hearings. I've read the decisions. Our labor boards, our case law are not about working Canadians. They're about the powerful elites at the top. And listen, I was a senior human resources executive in a multi-billion-dollar company, okay, with tens of thousands of employees in 2 countries. I worked for a country as the head of human resources in Canada that had 300,000 employees globally, okay? So I understand lobbying. I've been there as the senior human resources executive, okay? I know how that world works. I know what employers face from taxpayer-funded bureaucrats on behalf of employees. And I'm not saying that stuff shouldn't take place. But the fact that our system does not do the same for the rank and file workers who do not move in those lobbying circles and lobbying meetings, and they're not at the special events where these people are, their voices, there's nobody who speaks for them, truly speaks for them. And I really hope that they're going to have the freedom as workers in this country that the roughly 860 million workers of the Council of Europe have over there, either because governments didn't ever take away their freedom, or in the countries that did take away their freedom, their court gave it back to them, unlike our Supreme Court, which has been appalling globally on the issue of using the proportionality test to strip charter rights from Canadians.
Well, thank you very much, John Mortimer, for joining us today and for challenging us to think about how do we, frankly, rebalance labor relations in this country so that working people, all Canadians, can have a voice not only in our political process, but ironically within their union.
It'd be great to join the free world sometime in labor relations in this country. And maybe we'll have some premiers who will really care about the workers of their provinces, and we'll have a new prime minister who will do the same.
Thank you, John.
All the best.
Thank you for watching Leaders on the Frontier. We're a nonpartisan think tank. We explore ideas, policy, and practical solutions that can make a difference in the lives of Canadians. We do not accept any government funding. We work for you. Thank you for supporting Frontier. Visit fcpp.org to give. While you're there, be sure to check out our latest articles and research. Without open discussion and debate, you're not thinking, nor are you free. Comment below. We'd love for you to join the conversation.